The hearing opens calmly, almost routine, but this is where the foundation is set. By waiving the probable cause hearing, the parents make a choice that sounds technical, yet carries serious weight, quietly steering the entire case before emotions ever surface.
It looks like they're turning their cameras on.
All right. Mr. Kohler, can you hear me, sir?
Yes, I can.
Can you unmute
All right.
Your Honor, just so the foster care worker and the private agency worker are both in the waiting room and they'd like to be let in, please.
All right. Kylie, if you could let them in as well.
I believe I have
I
them.
see Brooke. Okay, thank you.
All right. All right. And Ms. Burns, can you hear me?
Yeah, I'm sorry,
sorry.
sir. I'm really sick. Is it unmuted?
All right. So you are Jessica Burns.
Yeah.
All right. My notes indicate that this is a preliminary hearing, that the last hearing was adjourned to allow the attorneys to talk to their clients, starting with you, Mr. Delaney. Where do things stand from your perspective?
My client, Jessica Burns, waives the probable cause hearing. She understands what that means, and then the matter would then be proceed to either mediation or a trial. But the probable.
All right, Ms. Burns, you heard what your attorney said. I don't know if you could, and is that what you want to do?
Yes.
Okay, all right. And Mr. Brown, as to Mr. Kohler?
Your Honor, I believe that I was unable to speak with him recently. I call and it's got calling restrictions, so I want to make sure I've got the right number first. But I spoke with him about a week ago, maybe 10 days or so, and I believe we're going to be able to come to a resolution. Correct me if I'm wrong, Mr. Kohler, but our last conversation, I think we were going to waive the preliminary hearing and follow the path that Mr. Delaney had laid out, set it for a pretrial with some mediation first.
Yes, sir.
All right, so so there's two waivers that are there. The court believes they are appropriate and will accept them and will authorize the petition. Ms. Hansel, do you have any objections to that?
No objection.
All right, and how are the children doing? I know it's a fairly new case.
The children are doing well, Your Honor, in accordance with the foster mother.
All right, I think is the foster mother here? I'd heard she was. Or maybe that's a foster care caseworker.
Stepmom.
All right. All right.
Judge, instead of setting this for a pretrial, I know Mr. Brown has made a proposal. We have the framework of a plea here for his client. However, I think we could really make some good progress in mediation, and then we could address Mr. Delaney's client. I also have an issue to bring up that Ms. Portman's here. She is the foster care worker from Child and Family Services. There's an issue of the parents drinking or showing up at parenting time.
Hold on just a second. Let me just deal with that mediation first. So this matter won't be, well, there will be a pretrial set, but mediation will be ordered at this point, as opposed to going to pretrial mediation and then from there. Mr. Brown, are you agreeable with this going immediately to mediation?
Yes, Your Honor, we can do that.
Mr. Delaney, are you as well?
Yes.
And Ms. Hansel?
Yes, sir.
Okay, so this matter will go to mediation. We will schedule that followed by a pretrial. So go ahead then, Mr. Sommerfeld.
Yeah, and I agree with what Mr. Sommerfeld has to say. Where they believe that
let him finish. Let him finish, then we'll see where things stand. So, Mr. Sommerfeld.
Judge, Miss Portman, she just brought up this has been happening recently. The parents, have the odor of alcohol, and she's requesting that there's. I know the department can always refuse a parenting time if it, is like a danger here. I think we need something like objective, like a a PBT or something that, the parents could take. It would give an instant result, and then it would settle any issues as to are the parents sober during parenting time. They have agreed to that. Ms. Portman has talked to them about it, and this issue is persisting. And if it keeps going on, and it could become a problem. The allegations in the petition have to do with things that have happened while allegedly under the influence of alcohol. So I just want to bring that up. It just came up. We haven't had a chance to file a motion or anything like that, but I think it's of an immediate concern because it involves parenting time and the children and the issues in the petition regarding drinking and things happening, which resulted in the removal of the children in the first place.
So are you asking for basically at this point a stipulated order that there be no alcohol, say 24-hour, no consumption of alcohol by the parents 24 hours before any visitation?
Well, that would work, Judge, but we would like to verify it on the spot.
Wait till
Yeah.
our
So-
time to talk, baby. Wait till our time, because we'll have
Hold
time
on,
to talk.
Jessica.
Hold on.
Wait.
Yeah.
Okay.
I'll mute. I'm sorry. I'll mute.
Okay, that's all right. So
But we get time to
I'm
talk,
first going to
right?
ask Mr. Delaney and Mr. Brown, or I guess the proposal, which isn't a motion yet, so wouldn't order it unless it's agreed upon, but that there be no consumption of alcohol 24 hours before any parenting time to be verified at the time of parenting time by a PBT.
Fine.
So, Ms. Let
Jessica,
me
hold on.
inquire of your attorneys first. Mr. Delaney?
All right. First of all, for Jessica's benefit, this is being sprung on us at a probable cause hearing. And while it's always meritorious to not have alcohol consumption at a parenting time, obviously my client's reacting to this because she wasn't aware this was going to be raised. And I don't know that she has stipulated to that. But
The tension truly kicks in. Allegations of alcohol use during parenting time hit the record, shifting the focus from paperwork to child safety, trust, and accountability, making it clear this case just became much more serious.
I think that generically the court would simply find that, consuming alcohol at a parenting time would not be appropriate. But I don't know that I can stipulate because I just didn't know about this. So I guess I'll leave it to the court. But, my client may be contesting these allegations and saying they're not true, but at the same time say, well, certainly we don't believe consumption is appropriate. So my reaction is because of the fact that I didn't have any advance notice, no pleadings were filed. So I'm running here on a live performance.
Ms. Burns, I'm not going to ask you at this time whether you consumed alcohol or not. Do you wish to consent to a PBT before any parenting time? It's up to you. I will not hold. Yes, you may.
Yes,
And
I
if
consent.
if your attorney
I
cuts you
consent.
off, stop.
My visits are already supervised, and we're great parents. And I will take it. I'll just do it.
All right. So you agree that you will not consume alcohol like 24 hours before any parenting time?
I'll even take a PBT.
And take a PBT. All right. Okay. Mr. Brown, your position?
Your Honor, again, Mr. Delaney laid it out pretty well that I had not spoken with Mr. Kohler about this. It would stand to reason you probably wouldn't exercise parenting time if you are under the influence of any substance, but alcohol seems to be raised here. If he would consent to that, that is fine. If he wants to talk to me before he does anything, that is fine as well.
Mr. Kohler? Are you in agreement with that?
I consent.
Okay, all right. That would be the stipulated order. Kylie, if you could put that. Actually, Mr. Sommerfeld, while I'll make the order immediately effective, I would like an order prepared that attorneys agree to. So this will be immediately effective. And is it Ms. Portman?
Yes.
Yeah, and so my understanding is that who would be actually administering the PBT?
I'm not sure if there's a court area that they can go, or
See, therein is probably part of the problem. The only place I'm aware of that does it is the sheriff's department.
okay.
But the order is, Ms. Sullivan, did you wish to add? Hopefully have the answer.
So we do have a new PBT machine at our office. It needs to be calibrated, but we've been told that we can't use that because that's not something that's admissible in court. But I did get trained and am certified to use the PBT machine. So I don't know that I would be available to do the PBTs, but we do have that machine available. I can take it to MSP and get it calibrated this week so that it's accurate.
Here's what I'm going to order: no consumption of alcohol 24 hours before parenting time. If there's a belief that there has been consumption of alcohol, the supervisor of parenting time can terminate it, but there should be a hearing right away if it is contested. But Mr. Sommerfeld, I would like there to be an order, since there wasn't a motion, and B, we're not quite sure the logistics, and hopefully you can work it out with Mr. Brown, Mr. Delaney, and Ms. Hansel, and if not, it should be set for a hearing. But the order is immediately effective, so no drinking 24 hours prior to any parenting time.
And then we can, if we suspect drinking, we can refuse parenting time. Is that how the order should read?
And exactly, and I would do what I would do in a domestic relations case if, in the event I made a finding that there had not, in fact, been consumption of alcohol, there would be entitlement to make up parenting time. But I don't expect this to be a problem. The parents are in agreement; they won't consume alcohol. Hopefully, there'll be a PBT, so there'll be a bright line test. Okay.
Your Honor, I just have one question, and maybe I misunderstood. Sure. Is this going to be a situation where they do a PBT every time they visit, or just if there's a suspicion?
Well, I hadn't got to that. I'm going to leave that up to counsel. In one sense, I don't have a problem with it, so it's a very short test with it being every time, but I'll leave that up to you guys, see if you can work that out. I don't want to get involved in an argument without the motion being brought. So, okay. All right, this is like legislation and sausage. You shouldn't watch it being made.
I like that.
I think we're done with the NA cases. We'll turn back to some DL cases now.
Thank you, Your Honor.
Thank you so much.
We're turning to Aiden Hill.
So am I off?
Yes, you're free to leave. Kylie, you can really just let everybody in who's there because we're running a little behind.
Thank you, Judge.
Yeah. All right, is Aiden here?
Yes.
All right, and Aiden, are you at school right now?
Yes.
All right, I gather that from the sign behind you. Is your mom here, or your guardian here, excuse me?
No. Well, I don't know, actually.
Okay, sure, I understand that. She wouldn't be there with you. Kylie, do you see Ms. Fowler?
It looks like everybody's, because I let everybody in, it's trying to let everyone in. It's just being slow.
Okay. Do you see her there, or are you not sure?
I think that she might be the Samsung one that we had earlier,
Okay.
but I'm not positive.
The court pivots to a new case, but the unease remains. Confusion over attendance, missing parties, and technical delays reveal how fragile the process can be when real lives depend on everyone showing up prepared.
I think she could potentially be the Brianna one as well.
It's us?
No, actually, that's not her.
Then we just joined.
I still have the Samsung one waiting to turn the video on.
All right, we're looking for Brenda Fowler. Is Ms. Fowler here? Aiden, do you see her?
I do believe that Brenda will be with Leah. Leah is who Aiden is temporarily residing with, and I do believe that is Leah on the Samsung.
Okay, is that correct, Leah? Can you hear me? All right, you are muted, I think.
Your Honor, I believe Brianna is actually with the Kohler McMurphy case that we just previously heard. So I'm not sure she's related to the DL cases.
All right. Well, I need Brenda Fowler here to proceed in this show cause, since there is no attorney.
I can have my daughter call her.
So I am on the phone with Brenda, and she's having troubles getting on right now. So
Give me her number, I will call her.
okay. Brenda, I'm just gonna have the judge call you, okay? Your Honor, it's gonna be 231-340-1248.
1248, I'm calling right now.
I'm trying to understand.
Hello? Hello, is this Brenda Fowler?
Yes, it is.
This is Magistrate or Referee Cooper. In this instance, we're here for a show cause hearing with Aiden. Aiden is here. And his probation officer is here as well. And that's you, Ms. DeFighter, is that correct?
Yes, Your Honor.
Yeah.
Okay, all right. So Ms. DeFighter is going to go ahead and describe the situation, and then we'll see where things stand. Ms. DeFighter, please.
Okay. All right.
Your Honor, since Aiden's show cause, his last show cause on Tuesday, January 13th, 2026, Aiden had a tether placed for 14 days, as well as his phone was confiscated by the probation department. On Wednesday, January 14th, Aiden was absent excused for that first hour, but then he was present for the remainder of the day. Thursday, he was also present the whole day and Friday. Then coming on Monday, they did not have school, and then Tuesday was closed due to a snow day. Then he was tardy on Wednesday. So Aiden is going to school more than when he previously was going to school, but the consensus was that he could get his phone back if he was not tardy or had no absences at school. So like I said, on Wednesday, January 21st, he was tardy to that first hour, but then present the remainder of the day. And then he was present majority of the next week. School was closed. There was a lot of snow days in there, so it kind of threw things off a little bit. Then he was tardy on Tuesday, January 27th. So he was then tardy, and that restarted his phone time. Aiden had his aunt call myself on Monday, January 26th to ask when he can get his electronics back. At that time, I told Aiden it had been only 3 days if I wasn't counting that last tardy, which would then restart his 5 days of no electronics. Aiden got very rude to me and aggressive. He said that it's been 5 days. This is not fair, questioning me. After back and forth of Aiden demanding his cell phone and me telling him that it has not been 5 days, nor has his behavior warranted his cell phone back, I told him that he could come to the courts on Wednesday, January 28th, to remove his court-ordered 14-day tether, but to not retrieve his cell phone. On Tuesday, January 27th, I had contacted Vanderbilt area schools to inquire why Aiden was tardy for first hour, and Christina Bunker, she's the school secretary, she confirmed that Aiden was late, arriving at 8:02. So Aiden is getting to school, but he's still struggling to get to school on time at a consistent basis. In the process of me talking to Christina Bunker about Aiden's absences or tardies in school, she let me know that a teacher had placed a comment in the attendance categories, and it read that student has returned to class after being absent nearly 99% of quarter 1 and quarter 2. He immediately displayed disruptive behavior and has now begun to have inappropriate conversations about another student and what men do in the shower. He is now instigating horseplay with male peers, including throwing things, grabbing, smacking each other, and influencing peers negatively, and wandering around the room while continuing horseplay. I have since had a conversation with Aiden regarding this, and Aiden claims that that is not him. He didn't do that, and was very rude in the sense of trying to redirect him into a better mindset and for him to just graduate school. Leo was actually present for this, and he was just rude to myself, rude to Leah. Leah said that he is doing well at home. However, she's asked him not to swear at home. To then, when Aiden heard that, started swearing. So he's just back to being disrespectful like we were when he first got placed on probation.
All right. So was my order that he would get his electronics back if he had 5 days of perfect attendance?
So what the order ended up being was 5 days, but you had to sign off on it.
Okay.
If Aiden were to attend school consistently for 5 days with no tardies or absences, I would have then approached you with the question if you could get his electronics back.
I remember that now. And how many days, consecutive days, does he have now as of today?
Let me check. As I was not here on Friday, so I was not able to pull grades. Give me 1 second.
Okay.
3.
So today is Tuesday, that'd be Friday, Monday, and today? Or?
So it looks like Friday they had a snow day, so it would have been Wednesday, Thursday, and then Monday. And then, I mean, we are in the middle of today, but he was tardy on last Tuesday.
So there'd be Wednesday, Thursday, today, Monday, or yesterday, Monday, Tuesday, Wednesday. If he continues on that process, he would get his things back, what, Thursday?
If he were to continue this, yes.
All right.
But my recommendations are different.
Go ahead.
Would you like me to say
Okay.
my recommendations?
Yes.
My recommendations are that Aiden's electronic devices remain in the probation department's possession for
The probation report lays out a troubling pattern: inconsistent attendance, behavioral concerns, and growing resistance to authority. With consequences looming, the question becomes unavoidable. At what point does accountability finally change behavior? If this breakdown helped you understand what's really happening inside the courtroom, hit like, subscribe to the channel, and tell us in the comments. Do you think the court is being too lenient here, or not strict enough? We'll see you in the next video.